Hello everyone, this is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to episode 332 of the FCPA Compliance Report. The FCPA Compliance Report is sponsored by Advanced Compliance Solutions, your one-stop shop for all things compliance related. Today I have with me Marc Bohn. Marc is a member at Miller & Chevalier, and we are going to take a deep dive into the Monday released decision by the United States Supreme Court in Kokesh versus Securities and Exchange Commission. It was a 9-0 decision authored by Justice Sotomayor, and it has lots of clear and important implications for the FCPA compliance practitioner. Most importantly, it held that profit disgorgements are a penalty remedy and not a compensatory remedy in a very esoteric discussion and ruling by the court. But the key for the compliance practitioner is that this means that remedy is subject to the 5-year statute of limitations. You cannot go back, or rather the Securities and Exchange Commission cannot go back more than 5 years to order profit disgorgement on any settlement. This case has lots of implications for the FCPA compliance community. Marc and I go through the background facts of the case, the rationale, the holding and the rationale, and then we take a look at what it really means for the compliance practitioner, not only in the calculation of damages, but also in your calculation of whether or not to self-disclose. Very interesting podcast. It comes in at just around 20 minutes. This is Tom Fox. Thank you very much for listening to this episode of the FCPA Compliance Report. Hello, everyone. This is Tom Fox, the Compliance Evangelist, back for another episode of the FCPA Compliance Report. Today, I'm here with Marc Bohn. Marc is with Miller & Chevalier, and we're going to talk about the Kokesh versus Securities and Exchange Commission case. For those of you who do not know Marc, first of all, you should, but second of all, he is one of the top commentators around profit disgorgement in the FCPA world. And as this case really deals exactly with that question, I wanted to get Marc on the podcast and see if we can go through it. So, Marc, there's a lot in this case. It's a short opinion, 9-0 decision written by Justice Sotomayor. So do you want to set the stage for us and then go off?
Sure. So Monday, a long-awaited opinion in Kokesh versus the SEC came down. It was a unanimous holding, finding that the SEC's use of disgorgement operates as a penalty under federal law and is therefore not freed from the 5-year statute of limitations that's established by 28 U.S.C. 2462, which is the U.S. Code's general statute of limitations governing civil enforcement. Would you like me to talk a little bit about the background of Kokesh or jump into the opinion?
Why don't we just jump into the opinion, because I really want to get into how the court came to the definition of penalty versus compensatory, and then really what constitutes a penalty thereafter.
Sure. So let me just spend 20 seconds setting up the Supreme Court opinion. Kokesh was an investment advisor. He was charged with, over the course of 14 years, using investment advisor firms, he had to misappropriate $35 million in publicly offered funds from several investment companies. So this opened him up to the jurisdiction of the SEC in their view. And following his conviction, he was ordered he was penalized, as well as ordered to disgorge $34.9 million, dating all the way back to 1996. He claimed that this should be covered by the 5-year statute of limitations, which would drastically curtail the amount of disgorgement imposed. He appealed this up to the district court, which upheld the decision. He appealed it up to the 10th Circuit, citing another circuit's decision holding that disgorgement was considered forfeiture and covered by the statute of limitations provision. And the 10th Circuit rejected his appeal. So we ended up at the Supreme Court. The Supreme Court accepted certiorari in January. On Monday, the Supreme Court, as I noted, held that disgorgement is a penalty subject to the 5-year statute of limitations. And in determining this, that SEC disgorgement qualified as a penalty, Justice Sotomayor, who drafted the opinion for a unanimous court, cited two governing principles. She said that whether the sanction is redressing a public wrong or a private wrong to an individual, and whether the sanction's purpose is to punish the wrongdoer and deter others from engaging in similar misconduct, or to compensate victims. So she kind of set up these two governing principles, and they're the rubric by which you analyze or determine whether a consequence or an obligation imposed by the court as a penalty. The court held that the application of these principles here readily demonstrates, not just in this case, but that SEC disgorgement period qualifies as a penalty within the meaning of 2462. Specifically, the court found that SEC disgorgement is one used to address the violation of public laws, meaning violations committed against the United States rather than an aggrieved individual. Two, that it's imposed for punitive purposes because the sanctions are intended to deter violation of public laws, and because those types of sanctions are inherently punitive, it constitutes a penalty. And three, that frequently disgorgement is not compensatory. The district courts have the discretion to determine how to distribute disgorged profits, but frequently they're giving it back to the Treasury. Once in a while, they may give it to a victim or do something else with it, but it's up to the court's discretion. And so setting out those three, viewing the disgorgement through these two principles, the court found that disgorgement bears, quote unquote, all the hallmarks of a penalty. It is imposed as a consequence for violating public law. It is intended to deter and not to compensate.
So based on that, that's what kicked it into the 5-year statute of limitations, if I understood the decision correctly.
Yes. So essentially, the court said that disgorgement is akin to a penalty, and it's subject to the same statute of limitations. And so the immediate consequence of that is any case that is on the SEC's desk right now that has conduct that dates beyond that period, where there is no tolling agreement, where the defendant hasn't waived the statute of limitations, it's dead in the water. The SEC can no longer bring that case.
So I thought it was interesting, and you certainly highlighted that penalties or remedies, rather, can be deterrents for a public wrong, a private wrong, and that could be a mixed bag for the remedy for the deterrence. But here it was pretty clearly because even if the money was paid under disgorgement, it was paid to the court, and the court would decide how the money was distributed, unlike a public remedy where disgorgement might be returned to individuals who were wronged by the conduct which violated the Securities and Exchange Act. Was that the way you read it as well?
Yes. That's exactly how I read it. The court actually, interestingly enough, notes that it acknowledges that there may be instances where disgorgement serves compensatory goals, where there are securities violations and the disgorgement is provided to the aggrieved victims. But they said that the fact that sanctions serve more than one purpose doesn't make them not punitive and doesn't make them not penalties. They said that a civil sanction can't be fairly said to be solely remedial if it has any retributive or deterrent purpose. So even if it's serving a compensatory purpose, if it has a punitive purpose as well, then it's a penalty.
Marc, one of the things that I found interesting was in the court's specific rebuttal of the SEC's position, they had characterized or at least questioned the way the SEC even calculated disgorgement, because they said that sometimes disgorgement is ordered without consideration of defendant's expenses that might reduce the amount of an illegal profit, and that somehow moved it away from actually being a compensatory disgorgement. What were your thoughts on that last section of the court's opinion?
I found it interesting. I mean, it was almost an aside. The SEC had made a big to-do about the fact that disgorgement was not punitive because it operated to restore the status quo, to put the party back in the position that it otherwise would have been in had it not kind of retained those illicit profits. And the court said they weren't convinced, and that the court noted that SEC disgorgement, and they cited examples, could be used or ordered without consideration of a defendant's expenses. And from personal experience, our firm has frequently encountered that in negotiations with the government over disgorgement amounts and penalties, et cetera. The SEC comes up with a profit figure, and If you were to argue, oh, we actually had a loss that year, and you pull out your finance books, your accounting books, that's not the way they calculated profits. And so the court noted that often or sometimes the disgorgement exceeded profits gained as a result of the violation. As a result, this was punitive because it left the defendant worse off than he otherwise would have been.
Right. And actually, I felt that part of the argument really tied into, if I could even flip it back to the equitable nature of the disgorgement remedy. Although I recognize there's a statutory basis for it, the court did draw on the history of the equitable nature of the remedy, and putting all parties back in the place where they began is one of the basic requirements of an equitable remedy. So I thought that part was very interesting. I pulled, Mark, the FCPA blog's top 10 disgorgement remedies, and it ran from Siemens of $350 million down to Technip of $98 million. What none of those cases told us was the period of time that the disgorgement covered, so whether it went back more than 5 years or not. But this case, I think, has lots of significant direct implications for your practice, for the compliance community. And I guess I wanted to see if we could maybe give our listeners a little insight into, does this mean, for instance, if there is, what's the starting point for the 5-year statute? Is it when an allegation arises? Was it when you self-disclose? Is it when the government comes knocking or you get a subpoena? And what happens if the investigation goes more than 5 years?
It's when the conduct occurs. And so, and the investigation, if it goes more than 5 years and there's no tolling agreement in place, then the SEC can't prosecute this. Part of this goes back to a landmark decision that occurred a few years ago, Gabelli versus the SEC, which found monetary penalties to be subject to the 5-year statute of limitations, and it addressed kind of this specific issue as to when that statute of limitations began to toll. The SEC would argue is when it found out about the violation, and the Supreme Court rejected that argument. And so the current case, that case didn't address equitable remedy, equitable relief. This case does, and so companies that, I think it's going to have the most immediate impact, the decision, to companies that are currently under investigation. And what it does is it gives a lot more leverage to defendants who are under investigation, particularly when one considers, as you note, that the lion's shares of monetary obligations imposed by the SEC in recent years have been via judgment, have been via disgorgement. And it's clear that the SEC's ability to reach conduct outside the statute of limitations period has served as a tremendous cudgel for the Commission over the years, and they've been able to use that as an incentive for companies to settle. I would note, I mean, in recent years, as much as $3 billion was disgorged, not just in FCPA cases, but overall by the SEC, say in 2015. And so here, limiting that to 5 years is going to be a direct benefit to companies. It's going to reduce the overall liability that they may face in connection with these types of investigations. It's going to increase their leverage in their hand in negotiations. Previously, defendants negotiating positions on liability and financial sanctions, they've been undermined by the SEC's ability to threaten massive disgorgement. And so Kokesh levels the playing field. Everyone is going to have to focus on conduct and sanctions that occurs within the statute of limitations period.
So do you think, or could you see this putting more pressure on the Commission to more quickly conclude investigations and move forward to dispose of cases, or would this conversely give companies more of an incentive to drag things out?
So I think, first of all, I think the court's decision puts immediate pressure on the SEC to resolve investigations more quickly as a means of minimizing statute of limitations issues. The DOJ has faced this. I don't want to overstate things, because the SEC generally solicits tolling agreements from cooperating defendants that waive the statute of limitations or toll them for a period of time or extend them. And the impact here, as a result, might be more muted than one might otherwise expect. But having this statute of limitations period be there strengthens the defendant's hand. Because previously, if they sought to narrowly tailor the waiver, the FCC would say, well, the tolling agreement doesn't apply to disgorgement because disgorgement has no statute of limitations. Now it does. And so if you push to narrow the waiver, then, or if defendants are less willing to enter into such agreements, then it's going to have an effect. And I think you're going to see defendants benefiting from that. It also could affect voluntary disclosure considerations. A colleague of mine noted that it could have an impact on companies' appetite in that regard, that if you have conduct that's 4 years old, 4.5 years old, you might be tempted to hold off a year before disclosing at all, and knowing that once that 5-year period hits, that the government can no longer pursue these massive penalties for that conduct anymore.
So we've been visiting today with Marc Bohn on the Kokesh versus SEC case. Once again, Marc is, I think, one of the top FCPA commentators around, specifically on profit disgorgement. He's written extensively on this. I'm going to link to some of his writings in the show notes. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance Report. If you have listened to this podcast on iTunes, I would greatly appreciate it if you would rate us, as that would help our rankings and help get the word out about the longest running podcast in compliance. Also, if you have any questions, please feel free to contact me at tfox@tfoxlaw.com. This is Tom Fox. Thank you again, and I hope you'll join me for another episode of the FCPA Compliance Report.